patent trolls. By 2012, the majority of patent suits were not brought by companies making products or even by entrepreneurs with legitimate claims. Instead, the majority of patent suits came from so-called patent trolls. What tactics do patent trolls use? Patent trolls file lawsuits to derive settlement revenue from defendants who are willing to settle for less than it would cost to defend against a patent infringement suit. In the U.S., patent litigation costs have become so high that many defendants would rather pay out a settlement than take the issue to court. Trolls often acquire questionable patents and file suit against multiple defendants. They rely on the presumption of validity accorded to all issued patents to extract settlements. Trolls tend to have few documents other than the patents and their file histories, and even fewer employees, so they face far lower discovery expenses than a commercial business with warehouses of documents and scores of employees would. Because discovery costs for these kinds of defendants are so much greater than for troll plaintiffs, defendants feel pressured to settle for less than the cost of litigation, which lines the pockets of trolls. In the aggregate, such activities have proven very profitable for trolls and very expensive for defendants. On the other hand, infringing companies nowadays routinely accuse plaintiffs of being patent trolls, even if the plaintiffs are legitimate patent owners. Infringing companies do this in an attempt to shift attention away from their behavior and to call into question the motives of those who dare to fight for their rights. What action has been taken to guard against patent trolls? Spurred by large companies that are often targeted by trolls, the America Invents Act, passed in 2011, included a change in rules governing the union of parties, stating, "Accused infringers may not be joined in one action as defendants or counterclaim defendants, or have their actions consolidated for trial based solely on allegations that they each have infringed the patent or patents in suit." This change prohibited a common tactic of trolls, filing a single case against multiple alleged infringers. However, trolls adapted by filing multiple lawsuits and seeking consolidation for the discovery process. This slightly increased the cost for patent trolls, but avoided the purpose of the change. More recently, politicians have scrambled to propose different legislative fixes, including shifting the cost of unsuccessful litigation to plaintiffs. Even President Obama has become involved, issuing a series of executive orders and proposing other ways to rein in patent trolls. Not everyone thinks change at the legislative level is necessary, however. In an op-ed piece for the New York Times, Chief Judge Randall Rader of the Federal Circuit Court of Appeals recommended foiling patent trolls by imposing costs and sanctions at the judicial level. But not everyone thinks this would solve the entire problem. Trolls rely on the threat of litigation expenses in order to extract settlements. However, trial judges cannot rule on the merits of a case without some basis, and that requires that defendants spend money, so it's hard for district court judges to prevent these predatory tactics. Getting to the merits of the claims takes time and money, often more than it would cost to settle, and with no assurance as to the outcome. Legislation was proposed in 2014 to address the problem, but it remains stalled, largely because many experts think it would also harm legitimate patent owners, especially startups. What's more, there have already been several state and federal actions taken to rein in abusive patent litigation. Some important U.S. Supreme Court decisions from 2015 limit the patentability of software and allow courts to make patent trolls pay the defendant's legal bills in exceptional cases where the suit is deemed abusive or frivolous. In light of these actions, it's less likely that new litigation will be introduced anytime soon. The new power to punish trolls by making them pay attorneys' fees is significant. Time will tell, though, whether it will reduce the pressure to implement legislation against abusive litigants. The Eastern District of Texas, one of the most popular venues for patent litigation in the U.S., added a new Track B docket, which specifically addresses a number of proposals considered by Congress, including early disclosure of certain information, such as licensing information, as well as very early disclosure of both the damages sought and the method of calculating those damages. Meanwhile, a growing number of state legislatures and state attorneys general have also begun using consumer protection laws to clamp down on the filing of bad faith demand letters by patent trolls. Finally, a movement is taking hold within the patent licensing industry itself to develop either a voluntary code of conduct or standards for ethical behavior. Companies like Dominion Harbor Group have committed themselves publicly to a set of ethical guidelines for patent licensing, and other companies are also considering doing so. The Licensing Executive Society of the U.S. and Canada, the industry's principal professional organization, is developing a set of best practice guidelines for ethical patent licensing activity. The importance of patents to America's economic prosperity and competitiveness ensures that competing interests will continue to use the patent troll issue to attain commercial, legislative, and judicial advantage.